Hello class, welcome back for exam number 3 review. We're all pretty much experts at this now. We know how this works. You've taken 2 exams, you've been through 2 of these reviews. This is a high-level overview of some of the concepts and material that I have found over the years that students struggle with the most. So I want to hit some of those highlights and highlight a few other things as well that I think it's important for you to know for the exam. So let's jump right in and get started. As with the first 2 exam reviews, I put some important information on there about how to prepare for exams. You are probably all experts at this by now. Just a reminder again that rarely, if ever, do I give makeup exams. If I am going to give one, there's going to have to be a very compelling reason, well documented. And then I, of course, consider the timeliness of communication in making decisions about granting makeup exams. You're late to an exam, you lose a point for each minute that you're late. If you arrive after the first person has handed in their exam, you're not allowed to take the exam. You receive a 0 on the exam. I take academic dishonesty very seriously. If there is suspected academic dishonesty, I would refer that to Judicial Affairs with a recommendation that you receive an F in the course. As you all know by now, exams can be pretty time compressed, so make sure you manage your time accordingly, and also recognize that once I call time at the conclusion of the exam, you have no additional time to keep writing or bubbling your Scantron. I bubble only what's on the Scantron and or Blue Book if you're in the honors class, so make sure you've got that all completed when time is called. For the non-honors class, same drill as the first 2 exams. You need a number 2 pencil, Form 882E Scantron. I'll begin handing out those exams right at the beginning of class time. Take me a couple minutes to do that. Start everybody on the exam at the same time. I will call time at 50 minutes past the hour. You'll have to stop writing immediately. If you don't, I'll refer you to Judicial Affairs. I'll give you a 5-minute and a 1-minute warning during the exam, and I'll put time up on the projector in class so you'll have an idea of where you stand. In the honors class, basically the same drill. You need a number 2 pencil, Form 882E Scantron, a Blue Book. Make sure you've got the bigger Blue Book. You can bring a pen along if you'd like to write your essays in pen. You may or may not be allowed to have a note sheet during the exam. We'll talk about that in class if one is permitted. I'll begin handing out the exams at the beginning of class. You've got 75 minutes to answer the exam. I'll give you a 5-minute and a 1-minute warning. When time is called, you've got to be done, have everything completed, bubbled, names on everything, filled out completely, and then I will display the time in class. Again, you all know this by now. Exams are challenging. This review is just a high-level overview, especially for this last exam prep. There are so many slides in this review that in order to be more efficient, I want to make sure that I hit the highlights so I can really stress the things that students have struggled with in past semesters. So studying the review alone is not going to be enough. You need to work practice questions, read through chapters, review notes, etc., and make sure you can apply the material that you've learned. So let's jump right in, chapter 28, and start talking about agency law. First, we started by talking about the agency relationship. And we talked about the fact that principals have substantial liability for the actions of their agents. So one of the key things that we discuss is that level of control that a principal has over an agent, which is what ultimately creates that liability for the principal. So what does it take to have an agency relationship? Well, we have a principal and an agent. In an agency relationship, the person for whom the agent is acting we call the principal. And in the agency relationship, the person who's acting on behalf of the principal is the agent. In an agency relationship, the agent agrees to perform a task for and under the control of the principal. So there's that control element again that's really important. To create an agency relationship, we have to have a principal and an agent. There has to be mutual consent that the agent act on behalf of the principal, be subject to the principal's control, and that thereby creates a fiduciary relationship, which we'll talk about in more detail shortly. So the first element is consent. This is pretty straightforward. The principal has to ask the agent to do something, and the agent must therefore agree. The principal also has to have control over the agents. That's what makes the principal liable for the actions of the agent, is the fact that the principal had control over the agent. So we have to have those 2 elements, consent and control, as well as a fiduciary relationship. And it's just a special relationship of trust. We'll talk about some of the elements that go into this fiduciary relationship shortly. But remember on the exam that all 3 of these elements have to be present. So if one of the elements is missing, we don't have a functioning agency relationship. We have to have consent, control, and fiduciary duty. Some things that are not required for an agency relationship, generally speaking, you don't have to have the agency relationship put in writing. Now, there's an exception to that, which we call the equal dignities rule. If an agent is empowered to enter into a contract, that must be in writing. So the principal is giving the agent the power to do something essentially that's governed by the statute of frauds. Then the appointment of the agent must also be written. We call that the equal dignities rule. We don't have to have a formal agreement, and there does not have to be compensation. So let's talk first about the duties that an agent owes to the principal. And these duties we collectively call fiduciary duties, and one of the biggest duties is the duty of loyalty. An agent has a fiduciary duty to act loyally for the principal's benefit in all matters connected with the agency relationship. The agent has an obligation to put the principal first, to strive to accomplish the principal's goals. So what this is saying is that the agent is supposed to make or put their needs second and the principal's needs or interests first. So the components of the duty of loyalty include this concept that an agent cannot receive profits unless the principal knows and approves. We call those outside benefits. So an example of this is accepting tips. The agent is not allowed to legally accept tips unless the principal has agreed to that, knows about it, and agrees to it. Agents can neither disclose nor use for their own benefit any confidential information they acquire during the agency relationship. That seems pretty straightforward, but the key thing that we emphasized in class is that this duty or responsibility to keep confidential information confidential continues even after the agency relationship terminates. Agents are not allowed to compete with the principal in any matter within the scope of the agency business. That's the default rule. Agent is prohibited from competing with the principal. When there's a conflict of interest between two principals, so unless otherwise agreed, so there are ways around this, but unless otherwise agreed, an agent may not act for two principals whose interests conflict. Very simple example of this is a real estate agent representing the buyer and seller of the same home. That would be a conflict of interest. Unless that home buyer and home seller agree, they know that that agent is representing both of them, the agent can't do that. That would be a conflict of interest between those two principals. If a principal hires an agent to arrange a transaction, for example, to go out and buy property on behalf of the principal, the agent cannot become a party to the transaction, for example, selling the principal property that the agent owns, without the principal's permission. So the agent would have to let the principal know, you wanted me to go out and buy property for you. I have this piece of property I want to sell to you. I think it's right for what you're looking for. If the agent secretly made that dealing with the principal without allowing the principal to know that the agent was the true owner of the property, that would be a violation of the duty of loyalty. An agent cannot engage in inappropriate behavior that reflects badly on the principal, and this rule by default generally applies to even off-duty conduct. An agent is bound by this duty of loyalty whether or not the agent and principal have consciously agreed to it. The duty of loyalty applies unless the principal and agent expressly agree to change it. So this whole duty of loyalty, all those elements we just talked about, are the default rules when we talk about the relationship between agent and principal. Some additional duties that an agent owes to the principal: they have the duty to obey instructions. Agent obeys principal's instructions unless the principal directs her to behave illegally or unethically, and the agent owes a duty of care to the principal. An agent has a duty to act with reasonable care. Agent with special skills, lawyer, doctor, accountant, etc., are held to a higher standard because they're expected to use those professional skills. We talked about that when we talked about negligence back in Unit 1. If you're a gratuitous agent, so you're not getting paid for your services, you're held to a little different standard. You're held to a lower standard because you're just doing the principal a favor. And gratuitous agents are not liable if they are liable only if they commit gross negligence, but not ordinary negligence. So the standard for a gratuitous agent is gross negligence. They're not liable for ordinary negligence, only for gross negligence. Agents also have a duty to provide information. So an agent has a duty to provide the principal with all information in her possession that she has reason to believe the principal wants to know. Agent also has a duty to provide accurate information. If an agent breaches the duty of loyalty, the principal has several remedies available to her. Damages. The principal can recover from the agent any damages that the breach has caused. If an agent breaches the duty of loyalty, that agent has to turn over to the principal any profits that he has earned as a result of his wrongdoing. And if the agent has violated her duty of loyalty, the principal may be able to rescind the transaction. So several options there available to the principal. Now we look at the other side of the coin, which are the duties or responsibilities that a principal owes to an agent. First is the duty to indemnify. And there are different categories, as you'll see in one of the bullet points here, but the key is this general rule. Principal has to indemnify or reimburse the agent for any expenses that she has reasonably incurred on behalf of the principal. Right? If the agent is out doing work, so if your boss asks you to go travel for work and you get a plane ticket, you rent a car, and you stay in a hotel, and you're spending money on meals while you're gone, the principal, your boss, should reimburse you for those expenses, indemnify you for those expenses. There's a duty to cooperate. So principals have a duty to cooperate with their agent. They can't stand in the way when the agent is trying to do the work. They have to fulfill their part of the contract. Now let's talk about how we can terminate an agency relationship. Either the agent or the principal can terminate the agency relationship at any time. Agency relationship can terminate automatically in certain circumstances if the principal or agent can no longer perform their required duties, or there's a change in circumstances that renders the agency relationship pointless. So we can have what's called a term agreement. The principal and agent can agree in advance how long their relationship will last. So it could be for time, 6 months, for example. It could be for the achievement of a purpose. The principal and agent can agree that the agency relationship will terminate when the principal's goals have been achieved. You hire an agent to sell your house, for example. When the house is sold, that will terminate the agency relationship. And no matter what they've agreed to, at the start, they can always change their minds later on and discharge the agreement by mutual consent. We can have what's called agency at will. So if there's no agreement in advance about the term of the agreement, then either the principal or agent can terminate at any time, and we call that agency at will. Now, when we talk about wrongful termination, there's an important distinction between power and right. Either party always has the power to terminate. So the principal can always fire the agent can always quit. They always have the power to do that. They may not, however, have the right. So if there's a contract, they have the power to walk out of the contract, but they don't have the right to do so, so they might be responsible for damages to the other party. If the agent's a gratuitous agent, meaning they're not being paid, they have both the power and the right to quit anytime, regardless of any agency agreement. Principal or agent can no longer perform required duties. There's one of these that is confusing on the exam. It shows up on the exam every time. Students get tripped up by it, so let's focus on that one in just a second. The first one is pretty easy, loss of qualification. If you hire somebody to be your lawyer and they lose their law license, that's going to terminate the agency relationship. They can't act as your agent anymore. I'm going to skip bankruptcy for just a second because that's the one that's tricky, and I'll come back to it. The death or incapacity of the principal or agent. If either one of those dies, that will automatically terminate the agency relationship. And then disloyalty of the agent also automatically terminates the agency relationship. The bankruptcy of the agent is the one that's tricky. The bankruptcy of the agent or the principal affects their ability to perform required duties. If that's the case, that will automatically terminate the agency relationship. But if, for example, if the principal goes bankrupt and can no longer pay the agent, or the principal goes bankrupt and closes all their stores, so there's nowhere for the agent to work, well, that's going to terminate the agency relationship because that affects or impacts the ability of the principal and the agent to perform under that relationship. If, however, an agent, so somebody who works at Walmart, files for individual personal bankruptcy, that doesn't in and of itself terminate the agency relationship because they can still show up and do their job. So it has to be something that affects the ability to perform in order for it to automatically terminate the agency relationship. There can be a change in circumstances. So if changes occur after the negotiating of the agency agreement and the changes are significant enough to undermine the purpose of the agreement, then the relationship ends automatically. So if war breaks out, that certainly could be something that is a change in circumstances that would terminate the agency relationship. If the law changes, that can terminate an agency relationship, or if the subject matter of the agency is lost or destroyed. So what's the effect of termination? Well, one of the keys is that once the agency relationship ends, the agent no longer has the authority to act for the principal. The agent loses her authority to act, but some of the duties of both principal and agent continue even after the relationship ends. The principal still has to indemnify the agent for any expenses the agent incurred while they were working in that agency relationship. And then, as we've talked about, the agent's responsibility to keep confidential information confidential continues even past the termination of the agency relationship. Now let's take a look at the liability to third parties. An agency relationship results in a dramatic increase in the risk of legal liability to third parties. So let's first talk about a principal's liability for contracts that an agent enters into on behalf of the principal. So the principal is liable for the acts and statements of an agent if the agent had authority or if the principal ratifies the acts of the agent. So it's essentially like when the agent goes out and acts on behalf of the principal with authority, it's essentially as if the principal has acted him or herself. In addition, the principal is deemed to know any information that the agent knows or should know. So that's an important concept that creates a lot of potential liability for the principal. So let's talk about authority. A principal is bound by the acts of an agent if the agent has authority. There are three general types of authority: express, implied, and apparent. Express and implied authority are categories of actual authority because the agent is truly authorized to act for the principal. In apparent authority, the principal is liable for the agent's actions even though the agent was not actually authorized to act in the first place. Express and implied authority are fairly easy and straightforward. You just have to know the distinction between the two, sort of memorize the definition. The principal grants express authority by words or conduct that reasonably interpreted cause the agent to believe the principal desires her to act on the principal's account. If there are things that are ambiguous about the principal's intent, the courts will look at the principal's objective manifestation, not subjective intent. We've seen that multiple times where courts emphasize and focus on objective viewpoints rather than subjective in most situations. So express authority would be if your boss tells you to go to the bank and make a deposit. You have express authority to do that. Implied authority is a little bit different. It says, unless otherwise agreed, authority to conduct a transaction includes authority to do acts that are reasonably necessary to accomplish it. So your boss told you to go to the bank and make a deposit. Well, when you show up at the bank, the teller says, in order for you to be able to make a deposit, you have to sign a couple of forms. Your boss did not give you express authority to sign those forms, but you have the implied authority to sign those forms. The law assumes that the agent has authority to do anything that is reasonably necessary to accomplish your task. So express and implied go hand in hand. They're relatively straightforward because they are actual forms of authority. Apparent authority is a little bit different. And there's something that tricks up students with apparent authority, and I want to emphasize it so you don't miss it on the exam. A principal can be liable for the acts of an agent who is not in fact acting with authority if the principal's conduct causes a third party reasonably to believe the agent is authorized. The key to questions on the exam about apparent authority is this: it only matters what the principal has done, not what the agent has done. The principal must have done something to create this appearance of authority. No matter how compelling, convincing the agent is in making third parties believe that they have authority, that will not be enough to create apparent authority. It must be something that the principal has done. That's always the key to these questions. Has the principal done something to create the appearance of authority? Principals can also ratify the actions of an agent, even if that agent was unauthorized to act. It takes a few requirements for this to be possible. The agent has to indicate to the third party that she's acting on behalf of the principal, and the reason agent is in quotes is because they actually weren't authorized, so they're not truly an agent. Principal knows all of the material facts of the transaction. Principal accepts the benefits of the whole transaction, not just part. and the third party does not withdraw from the contract before ratification. So that's a way that we can have ratification if all of those elements are satisfied, even if an agent acted in a way that was unauthorized. When we talk about subagents, that's someone appointed by an agent to perform the agent's duties. We can also have intermediary agents, someone who hires subagents for the principal. They come into play occasionally. You see it a lot in construction contracts, for example. And as a rule, an agent has no authority to make this delegation unless the principal authorizes them to do so. When an agent is authorized to hire subagents, the principal remains just as liable for the actions of those subagents as they are for the original agent. The intermediary agent usually escapes liability unless they were negligent in hiring. Now let's talk about the agent's liability for a contract. So you work for someone, principal, your boss, sends you out to go sign a contract, you sign the contract. The question is, if the principal breaches that contract, are you personally liable on the contract? Well, the agent's liability on a contract depends upon how much the third party knows about the principal. If we have what's called a fully disclosed principal, and this is important to know the distinction between the three types of principals that we have in this situation. A fully disclosed principal is a situation where the third party knows of the principal, both the existence and identity. In those circumstances, an agent has no liability on the contract. In the other two situations, unidentified principal and undisclosed principal, the principal and agent are jointly and severally liable. What that means is that all members are liable. So principal, agent in that group are both liable. They can be sued as a group, or any one of them can be sued individually for the full amount owed. The plaintiff obviously cannot recover multiple times what they're owed. So if they're owed $1 million and they sue the principal and get $1 million, they can't then sue the agent and get $1 million also. So they're entitled to the total sum of the damages, but they can recover it from the plaintiff, or from the principal, agent, or both. Half and half, doesn't really matter. The unidentified principal, which is sometimes referred to as partially disclosed, is a situation where the third party can recover either from the agent or the principal, like we just talked about, and a principal is unidentified if the third party knew of the existence but not identity. Undisclosed principal, the third party didn't even know that there was a principal involved. There's an exception with this undisclosed principal that a third party is not bound to the contract with that undisclosed principal if the contract specifically provides that the third party is not bound to anyone other than the agent, or the agent lies about the principal's identity because they knew the third party wouldn't want to interact with the agent or with the principal. If we have an unauthorized agent, somebody who has no authority, express, implied, or apparent, the principal is not liable to the third party and the agent is. That's pretty straightforward. The principal's liability for negligent physical torts. There's a concept called respondeat superior. It says a principal is liable for certain torts committed by an agent, and that transfers as let the master answer. So the person who's in charge, who has the control, is ultimately responsible. An employer is liable for physical torts committed by an employee acting within the scope of employment. When we talk about employees, there are two types of agents. There are employees and independent contractors, and generally a principal is liable for the physical torts of an employee, but not liable for the physical torts of an independent contractor. So how do we tell the distinction between the two? The key thing for you to understand is the more control a principal has over an agent, the more likely that the agent will be considered an employee. More control a principal has over the agent, the more likely the agent will be considered an employee. Based on companies that instead of hiring full-time employees use mobile apps to facilitate peer-to-peer transactions, like Uber, for example, we call this the gig economy. Are these freelance workers independent contractors or employees? An interesting question that the courts are somewhat unsettled on at this point. A principal is liable for the negligent and intentional physical torts of an independent contractor if the principal has been negligent in hiring or supervising her. So if the principal hires an independent contractor and does no background check, the principal can have liability for the negligent and intentional physical torts of that independent contractor. So when we talk about scope of employment, an employer is liable for a negligent physical tort committed by an employee acting within the scope of employment. An employee is acting in the scope of employment if that act is one that employees are generally responsible for, takes place during hours that the employee is generally employed, is part of the principal's business, is similar to the one in which the principal authorized, is one for which the principal supplied the tools, and is not seriously criminal. So if you think about this, if I do something outside of work, I'm coaching one of my kids' soccer games, and I punch the other coach, that's clearly not within my scope of employment. It has absolutely nothing to do with my job at UT Dallas. If, however, one of the UT Dallas coaches gets into a fight with another coach during a UT Dallas soccer game, basketball game, baseball game, whatever it might be, if they get into a fight while they're coaching, that is within the scope of employment. In authorization cases, the agent is working for the principal but commits an act that the principal has not authorized. Even if that act was expressly forbidden, the principal might be liable. It might be seen as within the scope of employment if it's the same general nature as the one that's authorized, or if it's incidental to the conduct that was authorized. When we talk about abandonment cases, the key that we talked about is that the employer is liable if the employee is on a detour. So just a minor diversion from whatever it is that they were supposed to be doing. But the employer is not going to be liable if the employee was off on a frolic of his own. The principal's liability for intentional physical torts. The principal is not liable for the intentional physical torts of the employee unless the following is true. The employee intended to serve some purpose of the employer, or the employer was negligent in hiring or supervising this employee. So we've seen a couple times here where it's really important that the principal, whether hiring an employee or an independent contractor, not be negligent in making their hiring decisions. The principal's liability for non-physical torts. A non-physical tort is one that harms only reputation, feelings, or wallet, and non-physical torts, whether intentional or unintentional, are treated more like a contract claim. So the principal is only going to be liable if the employee acted with express, implied, or apparent authority. Agents are always liable for their own torts. I emphasize this in class. Don't miss this on the exam, no matter how compelling my exam question is. Don't forget that agents are always going to have liability for their own torts. That wraps up Chapter 28, and now we get to transition to Chapter 29 and start discussing employment and labor law. An employee at will could be fired for a good reason, a bad reason, or no reason at all. Remember on the exam, this is still the default rule. If you do not have some sort of legal protection, you don't have a contract in place, one of the wrongful discharge claims that we discussed doesn't apply, there's not anti-discrimination legislation that protects you that we'll talk about in the next chapter, then you are an employee at will. You can be fired for any reason at all. And as it says here, for nearly a century, this was the basic common law rule of employment. It remains the default rule. Since the beginning of the 20th century, however, employment law has changed dramatically, and there have been more protections that have been added to the law. But again, in the absence of a specific legal exception, the rule in the United States is still that an employee at will can be fired for any reason. Several important exceptions to this rule today. We'll talk about some of the common law protections and a few statutory protections in this chapter and many more in the next chapter. So some of the common law protections, there's a concept in the common law called wrongful discharge. It says that an employer may not fire a worker for a reason that violates basic social rights, duties, or responsibilities. That's really a determination that's made by the courts. So one broad category of this is wrongful discharge violating public policy. This prohibits an employer from firing a worker for certain particularly bad reasons. And I want you to note when I say it prohibits an employer from firing a worker for certain particularly bad reasons, that's bad reasons as determined by the court. So here the court uses this idea that a bad reason is one that violates public policy. In essence, the public policy rule prohibits an employer from firing a worker for a reason that violates fundamental social rights, duties, or responsibilities. Courts have primarily applied the public policy rule when an employee refuses to violate the law, exercises a legal right, or takes action that supports fundamental societal values. So here's a summary of those: exercising a legal right, supporting societal values. And that brings us to contract law. So traditionally, many employers and employees and courts thought that only a formal signed document qualified as an employment contract. Increasingly, courts have started to take a slightly different view, and they've been willing to enforce employers' more casual promises whether those were written or oral. Courts are sometimes willing to imply contract terms in the absence of an express agreement. So if promises are made during the hiring process, sometimes courts will view those as contractual and allow fired or terminated employee to file a wrongful discharge claim claiming that contract rights were violated. Employee handbooks, as we discussed in class, can create contractual terms, and courts have held that there is a covenant of good faith and fair dealing even at some times in the at-will employment relationship. There's a wrongful discharge claim for tort law. So one of the most common is defamation. Usually happens if a former employer gives references, defamatory references about a former employee. Employers could be liable for defamation when they give false references about a former employee. More than half of the states, however, recognize a qualified privilege for employers who give references about former employees. And that qualified privilege says that employers who give references are liable only for false statements they know to be false or that are primarily motivated by ill will. Generally, courts have held that employers do not have a legal obligation to disclose information about former employees. That comes up frequently on the exam. The default rule is that as a former employer, I have no legal obligation to say anything at all about my former employees. When a new prospective employer calls me and says, please tell me about John who used to work for you, I have no legal obligation, generally speaking, to say anything. In the case of violence, some courts are now starting to say, okay, maybe that general rule shouldn't apply if there's violence. Maybe the former employer should be required to say something. Some recent cases, courts have held that when a former worker is potentially dangerous, employers do have an obligation to disclose this information. Again, remember on the exam, the default rule is don't have to say anything. A couple exceptions are starting to emerge, but still the default rule is that that former employer doesn't have to say anything. Courts and legislatures have been reluctant to consider bullying a violation of public policy, but extreme and outrageous conduct may amount to intentional infliction of emotional distress. So we're starting to see that emerge as a tort claim as well. The Family and Medical Leave Act, FMLA. United States is the only industrialized nation that does not require employers to offer paid sick leave. The Family and Medical Leave Act guarantees both men and women up to 12 weeks of unpaid leave each year. Simple exam question that tricks students up sometimes is, remember, it is 12 weeks of unpaid leave. If on the exam it says true or false, the FMLA provides 12 weeks of paid leave, you know that is false. It is unpaid leave. The things that it covers are childbirth, adoption, or a serious health condition of your own or of an immediate family member. Another area where I can ask questions about this on the exam, and often do, and it often tricks students up, is what constitutes an immediate family member? Well, for purposes of the FMLA, we're talking about a spouse, a child, or a parent. So siblings excluded from that list. Spouse, child, parent. An employee who takes a leave must be allowed to return to the same or an equivalent job with the same pay and benefits. You don't get paid while you're gone, but you get to come back to your original position. The FMLA applies only to companies with at least 50 workers and to employees who have been with the company full-time for at least a year. So those things are bolded, underlined. Obviously a good spot where I could ask questions as well. Have to have at least 50 workers, have to be full-time for at least a year in order to qualify for FMLA. We talk about whistleblowing. The key thing I want you to know with whistleblowing is employees who disclose illegal behavior on the part of their employer are considered whistleblowers, and as a general rule, whistleblowers are protected by the law. Now let's talk about off-duty activities and workplace freedom. In the absence of a specific law to the contrary, employers do have the right to fire workers for off-duty conduct. Lifestyle laws provide that an employer cannot terminate the employment of an employee as long as what they were doing off-duty was lawful. They're also entitled to use any lawful product when off-duty. So California is an example of a state that has a lifestyle law. We talk about smoking. Roughly 60% of the states, employers cannot prohibit workers from smoking. That's off-duty. Some workers have claimed that nicotine addiction is a disability under the ADA, but courts have been pretty skeptical of those claims. So with off-duty activities, employers, generally speaking, do have the right to fire workers for off-duty conduct, but things like lifestyle laws and smoking protection might place some limitations on that right. When we talk about alcohol and drug use, there's one key thing here that students get tripped up on. Generally speaking, it is easier for a private sector employer. And what I mean by private sector employer is Walmart, Toyota, Google, Dell Computer, Apple, Amazon. Those are not governmental employers. It is easier for a private sector employer to drug test than it is for a government employer. Government employer is the University of Texas at Dallas, other state entities, the federal government, the post office. Those are examples of government employers. It is easier for a private employer to drug test than it is for a government employer. Government employees can be drug tested for a drug or alcohol tested only if they show signs of use or if they're in a job where drug or alcohol abuse would endanger the public. So, for example, in the military or being a police officer or a firefighter. Those are situations where it's relatively easy for the government to drug test, but in most circumstances, it is much more challenging for the government to drug test than it is for private sector employers. When we talk about the right to free speech, we're really talking about this in the context of the National Labor Relations Act. It protects employees' right to unionize. The NLRA protects all unionized or not employees who engage in collective activity relating to work conditions and who are not supervisors. So even non-unionized workers cannot be fired for complaining about their jobs, so long as these complaints are shared with other employees and are not inappropriately hostile or violent. So you have that right to free speech in the workplace. When it comes to social media policies, companies' social media policies can violate the National Labor Relations Act if they unreasonably limit employee speech about work conditions. And the employer has the right to monitor a worker's electronic communications if the employee consents. The monitoring occurs in the ordinary course of business, or in the case of email, if the employer provides the computer system. So employers do have a decent amount of leeway to monitor electronic communications on the part of their employees. Under the Employee Polygraph Protection Act of 1988, employers cannot require or even suggest that an employee or job candidate submit to a polygraph test, except in the following cases: an employee who's part of an ongoing investigation into crimes that have already occurred, applicant for a government job, or an applicant for a job in public transport, security services, banking, or at pharmaceutical firms that deal with controlled substances. If an employer requires a polygraph test, it has to give advance written notice of when the test will be given and advise workers that they're entitled to legal counsel. In 1970, Congress passed the Occupational Safety and Health Act, abbreviated OSHA, to ensure safe working conditions. And under OSHA, employers have to comply with specific health and safety standards. Employers are under a general obligation to keep their workplace free from recognized hazards that are causing or likely to cause death or serious physical harm to employees. They have to keep records of all workplace injuries and accidents, and the Occupational Safety and Health Administration, also abbreviated OSHA, can inspect workplaces to ensure that they are safe. At least one court has held that it's reasonable for employers to store sensitive employee data electronically, even knowing that some of it will inevitably be stolen. So this is a broader societal conversation that we're having at the moment about what we value as far as privacy goes for our personal data. Guns. Employers have the right to prohibit guns in the workplace. In many situations, there are state laws that place certain restrictions on where you can prohibit guns, etc. But in almost half of the states, there are bring your gun to work laws, which prevent companies from banning firearms in the company parking lot. Let's talk a little bit about financial protections. Congress and the states have enacted laws that are designed to provide employees with a measure of some financial security. One example of that is the Fair Labor Standards Act, which regulates minimum wage, overtime, and child labor. Workers' compensation is another level of financial protection. The workers' compensation statutes ensure that employees receive payment for injuries that are incurred at work. They provide a fixed, certain recovery to the injured employee, no matter who is at fault for the accident. And what employees give up in exchange is they lose the right to sue their employer for negligence. We're talking about health insurance. Under the Patient Protection and Affordable Care Act, employers with 50 or more full-time employees must pay a penalty if they do not provide basic health insurance to their employees. Company insurance policies have to cover employees' children up to the age of 26. And there's legislation called the Consolidated Omnibus Budget Reconciliation Act, referred to as COBRA. It provides that former employees must be allowed to continue their health coverage for 18 months after leaving their job. Catch is that employees have to pay for it themselves, ultimately up to 102% of the cost. And COBRA applies to any company that has 20 or more workers. We talk about Social Security. The federal unemployment tax is part of the Social Security system, and it provides support to the unemployed. If a worker quits voluntarily or is fired for just cause, they're ineligible for unemployment benefits. While receiving payments, recipients have to make a good faith effort to look for employment. Federal Social Security system began in 1935 in the depths of the Great Depression. Social Security system pays benefits to workers who are retired, disabled, or temporarily unemployed, and to the spouses and children of disabled or deceased workers. Pension benefits. 1974, Congress passed the Employee Retirement Income Security Act. Here's a very important point for the exam. This often comes up. Under ERISA, ERISA, employers are not required to establish pension plans. There is no legal requirement that they have a pension plan. What ERISA says is if they do create a pension plan, if an employer chooses to create a pension plan, they then have to follow the rules of ERISA. Let's talk about labor unions, and we're going to talk about these at a fairly high level. We went through these relatively quickly in class, and we'll see why we go through them fairly quickly in just a minute. But in 1932, Congress passed the Norris-LaGuardia Act, which prohibited federal court injunctions if there were non-violent labor disputes. 1935, Congress passed the Wagner Act, which is generally known as the National Labor Relations Act, referred to by its abbreviation quite frequently as the NLRA. It ensures the right of workers to form unions and encourages management and unions to bargain collectively and productively. Section 7 of the National Labor Relations Act is really the cornerstone of union power, and it guarantees employees the rights to organize and join unions, bargain collectively through representatives, and engage in other concerted activities. It excludes supervisors. Section 8 of the National Labor Relations Act prohibits employers from engaging in certain unfair labor practices. Section 8 was then amended to prohibit unions from engaging in certain unfair labor practices. The NLRA also establishes the National Labor Relations Board that administers and interprets the NLRA, and it adjudicates labor cases. Here's the reason why we go through this relatively quickly. In the 1950s, about 25% of workers belonged to a union. Today, it's only about 11%. So public employees are much more likely to be unionized, but they're generally not covered by the National Labor Relations Act. If you want to organize a union, you seek exclusivity. So under Section 9 of the National Labor Relations Act, a validly recognized union is the exclusive representative of the employees. The organizing process involves a campaign, which deals with authorization cards. Generally, there'll be a petition seeking an election, then we have an election. And then if the union is authorized, once it's formed, a company then has to bargain with the union towards the goal of creating a new contract, which we call a collective bargaining agreement. Concerted action are any tactics that union members take in unison, so collectively, to gain some bargaining advantage. Most important times when a strike can be illegal, there's a cooling off period, there could be a statutory prohibition, sit-down strikes where members stop working but remain at their job post, blocking replacement workers, those are generally illegal, and partial strikes are also generally illegal. And that's when employees stop working temporarily, then resume, then stop again, and so forth. So partial strikes, sit-down strikes, situations where there's a statutory prohibition or anytime there's a cooling off period required. would make a strike, if it violated one of those terms, illegal. When employees go on strike, management does have the right to use replacement workers to keep the business operating. If it's an economic strike, an employer can hire permanent replacement workers, and an economic strike is one intended to gain wages or benefits. If it's an unfair labor practices strike, union members are entitled to their jobs back once the dispute has been settled, even if that means firing replacement workers. Picketing. The goal of picketing is to discourage employees, replacement workers, and customers from doing business with the company. Picketing the employer's workplace in support of a strike, generally lawful. Secondary boycotts are generally illegal, and a secondary boycott is a picket line established not at the employer's premises, but at a different workplace. Management has the ability to prohibit workers from entering the premises, which we call a lockout, and most lockouts are legal as well. So that wraps up Chapter 29, and we now transition to Chapter 30, which is employment discrimination. In Chapter 30, we turn our attention to employment discrimination and some of the key cases and legislation that have shaped employment discrimination law in the United States. So prior to 1964 is where we begin our journey, and we talk about equal employment opportunity and protection prior to the important legislation passed in 1964. The Fifth Amendment prohibits the federal government from depriving individuals of life, liberty, or property without due process of law. The 14th Amendment prohibits state governments from violating an individual's right to due process and equal protection. Courts have interpreted the provisions of the 5th and 14th Amendments to prohibit employment discrimination by federal, state, and local governments. The Civil Rights Act of 1866 provided that all people born in the United States, with the exception of Native Americans, were citizens of the United States and had the same rights as white citizens. This has been interpreted to prohibit racial discrimination in both private and public employment, but it is not applicable to the federal government. The Equal Pay Act of 1963 said that a worker may not be paid at a lesser rate than employees of the opposite sex for equal work. Equal work means tasks that require equal skill, effort, and responsibility under similar working conditions. The key is that workers cannot be paid differently based on gender. Here's what students often miss on the exam about this concept. A man and a woman doing the same job could potentially be paid differently. One might just be better at the job than the other. It might be a commission-based job. One might be more effective. Who knows? The key is that a man and a woman can be paid differently doing the same job, but they cannot be paid differently based on their gender. It has to be some other factor, some other non-discriminatory factor that is the justification for paying one more than the other. Can't be the gender. Now we get the Civil Rights Act of 1864. And under Title VII of the Civil Rights Act of 1964, it is illegal for employers with 15 or more employees to discriminate on the basis of race, color, religion, sex, national origin. This protection applies to every aspect of the employment process, from job ads to post-employment references, and includes hiring, firing, promoting, placement, wages, benefits, and working conditions of anyone who is in one or more of the so-called protected categories, which are race, color, religion, sex, national origin. There are 4 types of illegal activity under the Civil Rights Act of 1964: disparate treatment, disparate impact, hostile environment, and retaliation. All of these activities are illegal if used against anyone in a protected category. So let's start with disparate treatment. To prove a disparate treatment case, the plaintiff must show that she was treated less favorably than others because of her sex, race, color, religion, or national origin. The burden of proof is on the plaintiff. Have to prove that the employer intentionally discriminated, that the discriminatory motive might be inferred from differences in treatment. So let's take a little closer look. 3 required steps in a disparate treatment case. Step 1, this bold step here, plaintiff presents evidence that shows the following. She belongs to a protected category under Title VII, and it could be he also. This applies both ways. She suffered adverse employment action. The action occurred under conditions giving rise to an inference of discrimination. You're in a protected category. You suffered an adverse employment action. You didn't get the promotion. You didn't get the job. You got fired. You got demoted, whatever it might be. and that action occurred under conditions giving rise to inference of discrimination. You're an African American female, you applied for a job, you didn't get the job, a Caucasian male was hired. You're in a protected category, you meet step 1. You suffered an adverse employment action, you didn't get hired. Step 3 of this first part is the action occurred under conditions giving rise to an inference of discrimination. It looks like maybe this is something that happened, so we can look a little bit further. If the plaintiff can show those 3 facts, they have made what's called a prima facie case. And that's from the Latin meaning from first appearance. So something that on its face appears to be true. In the first step, the plaintiff is not required to prove discrimination. Only has to create this presumption that discrimination may have occurred. So that's step 1. Step 2, the next bolded subpoint, says the defendant must present evidence that its decision was based on legitimate non-discriminatory reasons. So now the burden is back to the defendant. The defendant has to say, wait a second, it doesn't have anything to do with your race, your skin color, your religion. It has to do with these factors that are non-discriminatory. Now, if the defendant has done that, the burden shifts back to the plaintiff, and now to win, the plaintiff has to prove that the employer intentionally discriminated, although this motive can be inferred from differences in treatment. She can do this by showing either that the reasons offered were simply a pretext or a cover, or that a discriminatory intent is more likely than not. So that's disparate treatment. Now we talk about disparate impact. It applies if the employer has a rule that on its face is not discriminatory, but in practice excludes too many people in a protected group. I think one of the simplest examples of this is applying for a job to be a firefighter. If there's a physical fitness test associated with that application process, that could potentially be an example of disparate impact. If the test is passed at a higher rate by men than it is by women, there is a disproportionate impact on a protected group, women. The plaintiff does not have to prove intentional discrimination in disparate impact cases. The required steps in a disparate impact case are the following. Plaintiff has to present that prima facie case. And in that first step, the plaintiff is not required to prove discrimination. He need only show a disproportionate or disparate impact. That the employment practice in question, so in our example, this physical fitness test, excludes a disproportionate number of people in a protected group. The Equal Employment Opportunity Commission defines a disparate impact as one in which the pass rate for a protected category is less than 80% of that for others. That's the first step. Second step, defendant has to offer some evidence that the employment practice was a job-related business necessity. Look, this is what firefighters actually have to be able to do. So it's a job-related business necessity that they be able to climb this fast, lift this much, run this far. Then the burden shifts back to the plaintiff, and then to win, the plaintiff now has to prove either that the employer's reason is a pretext, again, just a cover, or that other less discriminatory rules would achieve ultimately the same results. We can have a hostile work environment under Title VII. Employers violate Title VII if they permit a work environment that is so hostile towards people in a protected category that it affects their ability to work. This rule applies to hostility based on race, color, religion, sex, national origin, pregnancy, age, or disability. So a pretty broad category. We talked about sexual harassment and the 2 types of sexual harassment. There's quid pro quo, which is harassment that occurs if any aspect of a job is made contingent upon sexual activity. And we also talked about hostile work environment, a situation where an employee can have a valid claim of sexual harassment if sexual talk and activity are so pervasive that they interfere with the employee's ability to work. Same-sex harassment, the Supreme Court has ruled that same-sex harassment is also a violation of Title VII. And as we've talked about, under Title VII, we can have hostile environment based on race, color, national origin as well. Employer liability for harassment. So the Supreme Court has held the following. This is important. A company is liable if it knew or should have known about the condition or conduct and failed to stop it. That's pretty straightforward. If the company knows what's going on, or it's pretty obvious that they should have known what was going on, then they probably should be liable, and the courts have held that they are. Even if the company was unaware of the behavior, it's nonetheless liable if the victimized employee suffered a tangible employment action. Firing, demotion, not being hired for something, passed over for better job assignments, not getting a raise, whatever it might be, firing, demotion, reassignment, they are liable because this tangible employment action occurred. If the company was unaware of the behavior and the victimized employee did not suffer a tangible employment action, company is still liable unless it can prove the following. It used reasonable care to prevent and correct harassing behavior, and the employee unreasonably failed to take advantage of the complaint procedure or other preventative opportunities provided by the company. Title VII also legally prohibits retaliation. It prohibits employers, Title VII does, from retaliating against workers who oppose discrimination, bring a claim under the statute, or take part in an investigation. Standard of proof is higher in retaliation claims. In a basic discrimination case, a plaintiff can win by showing that discrimination was a motivating factor, even though other factors might have been involved. In a retaliation case, the plaintiff has to demonstrate that but for the defendant's desire to retaliate, he would never have taken the harmful action. And the standard is called but-for causation. Title VII prohibits disparate treatment, disparate impact, hostile environment, and retaliation when used against any of the categories protected by Title VII. Let's talk about religion. Employers cannot discriminate against a worker because of his religious beliefs, and in addition, employers have to make reasonable accommodation for a worker's religious practices unless the request would cause an undue hardship for the business. So courts would weigh the decision about reasonable accommodation versus undue hardship to make a determination as to what an employer would be required to do. The Supreme Court has ruled that gender must be irrelevant to employment decisions under Title VII of the Civil Rights Act of 1964. The Supreme Court has also ruled that Title VII forbids sexual stereotyping. When we talk about attractiveness, unattractiveness, the lack of attractiveness, is not a protected category under Title VII. So attractiveness is a basis that employers can, under federal law at least, legally make determinations based upon. Unmarried, childless women earn 96% of what men do, while married mothers earn 76%. Family responsibility discrimination is a violation of Title VII if it involves men and women being treated differently. The Equal Employment Opportunity Commission has issued guidelines indicating that stereotypes are not a legitimate basis for personnel decisions and may violate Title VII. Some state and local laws prohibit either parenthood discrimination or family responsibility discrimination. We talk about sexual orientation. The specific language of Title VII does not include sexual orientation as a protected category, but some courts are now interpreting the statute to include sexual orientation as a protected category. By executive order, the federal government prohibits discrimination based on sexual orientation among its own employees and also among government contractors. Almost half of the states and hundreds of cities have statutes that prohibit discrimination based on sexual orientation. The Supreme Court has ruled that it is unconstitutional to withhold federal benefits from same-sex married couples. But this inconsistency in federal law, meaning somebody could be fired because of their sexual orientation, but they're entitled to same-sex benefits, or same-sex couples are entitled to married couple benefits, could oftentimes place a person in a difficult situation if they decide to claim those benefits. Traditionally, courts have taken the view that sex under Title VII applied only to how people were born, not what they chose to become. Courts assumed that gender nonconformity was a personal choice, but some courts and the Equal Employment Opportunity Commission have started to take a different view. This is a developing trend where gender identity and expression are receiving more protection under the law. Background and credit checks. EEOC regulations prohibit companies from using criminal history information in a way that has an adverse impact on employees in a protected category if that background information is irrelevant in determining whether the employee is appropriate for the job. Employers should not consider arrest records because that's no evidence of wrongdoing. And the Equal Employment Opportunity Commission also discourages the use of credit checks. Under Title VII, it is illegal for employers to discriminate against non-citizens because of their national origin, but employers are permitted to ask if a person is authorized to work in the United States. Reverse discrimination is making an employment decision that harms a non-Hispanic white person or man because of his gender, color, or race. As a general rule, it is just as illegal as discriminating against a minority or a woman. However, there is one exception to this rule, which is affirmative action. And affirmative action programs are programs that are designed to remedy the effects of past discrimination. Affirmative action programs are not required by Title VII, nor are they prohibited. Some defenses to charges of discrimination. One is merit. A defendant is not liable if he shows that the person he favored was the most qualified. Seniority. A legitimate seniority system is legal even if it perpetuates past discrimination. And the bona fide occupational qualification. An employer is permitted to establish discriminatory job requirements if they are essential to the position in question. Only religion, sex, or national origin are even eligible for this particular defense. Courts almost always reject this defense when it's based on customer preference, but the court does recognize 3 situations in which employers can consider preference. That's safety, privacy, and authenticity. The Pregnancy Discrimination Act says that an employer may not fire, refuse to hire, or fail to promote a woman because she is pregnant. The employer also violates this statute if the work environment is so hostile towards a pregnant woman that it affects her ability to do her job. The employer has to treat pregnancy and childbirth as any other temporary disability. The Pregnancy Discrimination Act also protects a woman's right to terminate a pregnancy. An employer cannot fire a woman for having an abortion. The Age Discrimination in Employment Act kicks in once an employee reaches the age of 40 or older. In those circumstances, they are protected by the Age Discrimination in Employment Act. Employers cannot require workers to retire at a certain age, although there are some exceptions to that, like airline pilots, police officers. There are disparate treatment claims under the Age Discrimination in Employment Act. We've talked about this a little bit. There are a few tweaks in the general disparate treatment analysis, but it's roughly the same as what we've already discussed. Same thing with disparate impact. There are 2 steps with the disparate impact claim when we talk about age, but roughly the same analysis that we've seen. There can also be a hostile work environment claim under the Age Discrimination in Employment Act, and there might be situations where there's a bona fide occupational qualification defense if an employer can show that the age limit that they have placed is reasonably necessary to the essence of the business, and that either virtually everyone of a particular age is unqualified for the job, or age is the only way an employer can determine who is actually qualified. Now we talk about discrimination on the basis of disability, and we start with the Rehabilitation Act of 1973, which prohibits discrimination on the basis of disability by the executive branch of the federal government, federal contractors, and entities that receive federal funds. It also requires these organizations to develop affirmative action plans for the hiring, placement, and promotion of the disabled. We then shift and talk about the Americans with Disabilities Act, which prohibits employers with 15 or more workers from discriminating on the basis of disability, and disability is very broadly defined. A disabled person is someone with a physical or mental impairment that substantially limits a major life activity or the operation of a major bodily function, or someone who is regarded as having such an impairment. The ADA does apply to recovered drug addicts. It does not apply to current drug users, individuals with certain types of sexual disorders, people who suffer from pyromania, exhibitionism, or compulsive gambling. Alcoholics are covered by the ADA if they can meet the definition of disabled, so they have to show that they meet the definition of disabled. But employers can fire alcoholics if their drinking adversely affects their job performance. Even if the disability, this is important, even if the disability can be successfully treated, the employee is still considered disabled. So an example is someone who suffers from diabetes but is able to treat and manage their diabetes is still considered disabled for purposes of the Americans with Disabilities Act. An exception to this is a person with normal vision when corrected with contact lenses or glasses is not considered disabled for the purposes of the ADA. Once it's established that a worker is disabled, employers cannot discriminate on the basis of disability as long as the worker can, with reasonable accommodation, perform the essential functions of the job. An accommodation is not reasonable if it creates an undue hardship for the employer. So 3 key components to making a determination as to how we accommodate a disabled worker. First, what are the essential functions of the job? So we want to know exactly what somebody truly has to do essentially to be able to function in this job. Then we want to know what reasonable accommodations would have to be made to that worker so they could carry out those essential functions. And then we want to balance that against any potential undue hardship on the employer. Employers are expected to make facilities accessible, permit part-time schedules, acquire or modify equipment, assign a disabled person to an open position that he or she can perform. So employers do have an obligation to make an attempt at reasonable accommodation unless they can prove that it is truly an undue hardship. The essential functions of the job essentially are what are truly the essential functions of this job. What do you actually have to be able to do this on a daily basis? And when we talk about undue hardship, many courts hold that employers are able to use cost-benefit analysis in making a determination as to what constitutes an undue hardship. When we talk about medical exams, if we have an applicant, an employer generally may not require a medical exam or ask about disabilities of an applicant, except the interviewer can ask the following things. Whether the applicant can perform the work, provided the same question is asked of everyone, for the applicant to demonstrate how they would perform the job, and in the event that a disability is obvious, what accommodation that applicant would ultimately need. Once someone has been hired, they're an entering employee, the company can require a medical test and make it a condition of employment, but the test has to include or be carried out this way. Required of all employees in similar jobs, whether or not they are disabled, and treated as a confidential medical record. And for existing employees, an employer may require medical exams or discuss any suspected disability, but only to determine if a worker is still able to perform the existing functions of her job. One thing that I really like about the Americans with Disabilities Act is that it includes protection for people who have a relationship with a disabled person. An employer may not discriminate against someone because of his relationship with a disabled person. So if you're caring for a child with a disability, or a parent or a sibling with a disability, or a spouse with a disability, an employer can't discriminate against you because of that relationship that you have with that disabled person. When we talk about obesity, according to the Equal Employment Opportunity Commission, simply being overweight is not a disability unless it has an underlying physiological cause, such as a thyroid disorder. But if you are morbidly obese, which is defined as having double the normal body weight, that is considered a disability regardless of what the cause is. Under the Equal Employment Opportunity Commission rules, physical and mental disabilities are to be treated the same. When we talk about discrimination on the basis of disability, we have disparate treatment and disparate impact claims. The steps are essentially the same as what we have already seen, so we don't need to walk back through them. But it's that same analysis of disparate treatment and disparate impact. We can also have a hostile work environment claim under the Americans with Disabilities Act. Now we talk about Genetic Information Non-Discrimination Act, referred to as GINA. Under GINA, employers with 15 or more workers may not require genetic testing or use information about genetic makeup or family medical history as a factor in hiring, firing, or promoting employees. Health insurers are also prohibited from using such information to decide coverage or premiums. Some general hiring practices. Bottom line is to avoid questions that relate to protected categories when you're carrying out interviews. Employers can learn things by going and looking at social media that might tip them off to someone's inclusion in a protected category. Best practice is probably what some employers are doing, and they separate the roles of hiring and cyber vetting. So somebody makes a hiring decision and then somebody else goes and checks all the social media to make sure that that's appropriate. You probably want those two decisions separated. That way the person making the hiring decision doesn't stumble upon something that relates to a protected category or someone's inclusion in a protected category. So how are these laws enforced? Well, with constitutional claims, if someone wants to bring a constitutional claim, they file a lawsuit on their own. Under the Civil Rights Act of 1866, plaintiffs that allege racial discrimination might use the Civil Rights Act of 1866 because it offers some advantages over Title VII. First, there's a 4-year statute of limitations as opposed to less than a year under Title VII. There are unlimited and compensatory damages, compensatory and punitive damage under the Civil Rights Act of 1866. It applies to all employers, not just those with 15 or more employees. It's not enforced by the Equal Employment Opportunity Commission, so the plaintiff would have to negotiate or sue on their own or hire their own lawyer to do so. The Rehabilitation Act of 1973, it's enforced by the EEOC if there are claims against the executive branch of the federal government, enforced by the Department of Labor for claims against federal contractors, and by the Department of Justice for claims against entities that receive federal funds. When we look at other statutory claims, the EEOC is the federal agency responsible for enforcing Title VII, Equal Pay Act, Pregnancy Discrimination Act, ADEA, ADA, and GINA. Before the plaintiff can bring a lawsuit under any of those statutes, with the exception of the Equal Pay Act, they first have to file a claim with the EEOC. There are statutory limitations on damages in many instances, and employers are increasingly requiring arbitration for any of these types of claims. Chapter 31 now allows us to turn our focus to starting a business, and we focus on limited liability companies and several other options. So to begin, entrepreneurs have to select a form of organization. The correct choice allows them to reduce taxes, liability, and conflict while facilitating outside investment. And if entrepreneurs do not make a choice for themselves, the law will automatically select a default option, which might be undesirable given the circumstances. So let's start our discussion by talking about sole proprietorships. This is an unincorporated business owned by one person, and remember, it is the most common form of business in the United States. The advantages of a sole proprietorship: it's really easy to form, it's easy and inexpensive to create and operate, and a sole proprietorship is a flow-through tax entity. So when you're preparing for the exam, I want you to be 100% certain that for all of the entities that we emphasize and focus on, that you understand the tax structure of that entity and that you understand the personal liability of the owners of that entity. Okay, so make sure you understand taxes and personal liability. So when we talk about the taxes of a sole proprietorship is what we call a flow-through tax entity. It's an organization that does not pay income tax on its profits. So a sole proprietorship is a non-taxable entity. The income that it earns passes through to its owners, in this case, sole proprietor, it's one owner, who pays the tax at their own individual rates. So that's what we call a flow-through tax entity. Okay, we're going to contrast that with a corporation shortly, which is a double-taxed entity. The disadvantages of a sole proprietorship is that personal liability. A sole proprietor is personally liable for all the debts of the organization. There's nobody else that could be liable. It is just that sole proprietor. That's the representation of the business. Another disadvantage, there are limited capital options, and debt is generally the only source of working capital. So we see this chart throughout Chapter 31. Entity, sole proprietorship, personal liability for the owner. The answer is yes. The taxes flow through tax, not a taxable entity. Formation is pretty easy. Financing is limited. Now let's talk about corporations. 1811, New York became the first jurisdiction in the United States to permit routine incorporation. The advantages of a corporation: limited liability. Shareholders do not have personal liability for corporation debts. That's different than when we just talked about the sole proprietorship, which does have unlimited personal liability. What this means is if you are a shareholder of Apple and Apple goes bankrupt and they have no money, the creditors, the people who are owed money, are not going to come knocking on your door asking you to give more money if you're a shareholder. Now, that being said, if you invested $1 million in Apple stock and it went to zero, you lost that $1 million. That's gone. The money that you invest in the business is always at risk. What we are talking about here is personal liability beyond the amount that you invested in the business. That's what you want to protect yourself from. You do not want to have personal liability. So this is an advantage of a corporation. A corporation shields managers and investors from personal liability for the debts of the corporation and the actions of others. But as we saw when we talked about agency law, not against liability for their own torts and crimes. Always going to be liable for your own torts and crimes. Another advantage, the interests are fairly easily transferable. Corporate stock can often be bought and sold easily. And there's a perpetual existence, meaning that these entities can continue even without their founders. Disadvantages of a corporation: corporations require substantial expense and effort to create and operate, certainly more so than a sole proprietorship. And the taxes. A corporation is a taxable entity, meaning a corporation pays income tax. Then if it distributes money to shareholders, they do that through what's called a dividend. The shareholders have to pay tax on the dividend. That's double taxation. Corporation pays tax, shareholders pay tax. That's double taxation, and that is a disadvantage of the corporate form of entity. So here's we can see sole proprietorship still there, and now corporation. Personal liability for the owners, no, that's a big advantage. Taxes, double tax, so a corporation is a taxable entity. Formation can be time-consuming and costly. Financing, there's a lot more flexibility than there is with sole proprietorship. Some special types of corporations. The S corporation is the one that we're going to focus on primarily. The name S corporation comes from the provision of the Internal Revenue Code that created this particular form of organization. Shareholders of S corporations get the benefit of limited liability, which we saw as a big advantage, and the tax status of a flow-through entity, which we also saw as an advantage. The reason that there aren't more S corporations are because there are really big major restrictions on being an S corporation. You can only have one class of stock, can't have more than 100 shareholders. Shareholders have to be individuals, estates, charities, pensions, funds, or trusts, no partnerships or corporations. Shareholders have to be citizens or residents of the United States, not non-resident aliens, and all shareholders must agree that the company should be an S corporation. So there are a lot of hoops that you have to jump through to be an S corporation. But now we add S corporation into our analysis here. We can see no personal liability for the owners of the S corporation. That's a good thing. There's flow-through tax, which is also a good thing, meaning the S corporation is a non-taxable entity. There are formalities and expenses involved in forming the S corporation, and financing is somewhat flexible, but we just talked about all those limitations. We talk about close corporations. That's a corporation with a small number of shareholders whose stock is not publicly traded and whose shareholders play a very active role in management. Close corporations entitled to special treatment under some state laws. A common theme of a close corporation statute is there's protection for minority shareholders, restrictions on transfer, a little bit more flexibility in how they carry out the requirements, and they're built into the statute dispute resolution provisions. A limited liability company, or LLC, offers the limited liability of a corporation and the tax status of a flow-through entity. That's what we're looking for. That's the good combination that we want, is that limited personal liability and flow-through tax status. The owners of the LLC are called members. General LLC concepts are what we discuss, but of course you'd want to check state law if you're going to look further into forming an LLC. Members are not personally liable for the debts of the LLC. That's what we want. We want that limited personal liability. The tax status, they get that flow-through tax status, which is also something that we want. When it comes to formation, the only required document of an LLC to form it is the certificate of organization, sometimes called a charter. It's short, contains basic information, name and address, has to be filed with the Secretary of State in the jurisdiction in which the LLC is being formed. LLC should have an operating agreement, sets out rights and obligations of the members, although it's not legally required. Unlike the S Corp, LLCs can have members that are corporations, partnerships, or non-resident aliens. Not required to hold annual meetings or maintain a minute book, and allowed to have different classes of members, so a lot more flexibility than the S corporation. Unless the operating agreement provides otherwise, existing members of an LLC cannot transfer their ownership rights, nor can the LLC admit new members without the unanimous permission of the other LLC members. LLCs cannot issue stock options, which can be a detriment as they try to go public or try to get venture capitalists to invest. The trend is towards allowing LLCs to continue even after a member withdraws, unless the operating agreement would provide otherwise. Once an LLC goes public, it loses that favorable tax status and it gets taxed as a corporation. So most LLCs would make the decision to change to a corporation prior to going public. Now, a change from a corporation to an LLC is considered a sale of all the corporate assets of that entity by the Internal Revenue Service, and the value of all those assets would be taxed. A change from partnership to LLC or from LLC to corporation is not treated as a sale of the assets, so you avoid that tax implication. Piercing the company veil is a situation where a court holds a member of an LLC personally liable for the debts of the organization, and this can occur if the LLC or the owner member of the LLC failed to observe formalities, commingled assets, or had inadequate capitalization for the LLC, or was just out to commit fraud through the use of the limited liability company. There's some legal uncertainty involving LLCs because they're still a relatively new form of business organization, although that is starting to diminish. They're starting to become more consistent. If you're deciding between an LLC and a corporation, the advantages of the LLC are that tax status, being able to avoid the restrictions of an S corporation. It has less formal rules than an S corporation or than a corporation generally. The disadvantages of an LLC, if it's done properly, it's more expensive to set up than a corporation. And venture capitalist investors sometimes prefer C corporations because LLCs have some arcane tax issues. C corporations are easier to merge, sell, or take public, and there's still some legal uncertainty out there involving LLCs. So now we add limited liability companies to our mix. Personal liability for the members who are the owners, no. It's a flow-through entity unless it decides to go public. Limited liability company is not a taxable entity until it goes public. There are some formalities and expenses involved in the formation, and there's some flexibility in financing. Social enterprises are organizations that pledge to behave in a socially responsible manner even as they pursue profits. They are not nonprofits. Their focus is on the triple bottom line: people, planet, profits. General partnerships. An unincorporated association of two or more co-owners who carry on business for profit. Each co-owner is called a general partner. They get that pass-through or flow-through tax status. So a partnership is not a taxable entity. The individual partners pay income tax. Each partner is personally liable in a general partnership. This is the biggest downside of the general partnership. Very few businesses are deliberately going to choose to be a general partnership. Easy to form. Best practice would say to have a written partnership agreement, but one is not required. If two or more people do business together, share management, profits and losses, they have a partnership, whether they know it or not. So this is sort of a default that you don't want to be in. In the absence of a partnership agreement that provides to the contrary, all partners in a firm have an equal right to share in management. Management becomes increasingly difficult as the partnership grows. Capital needs of the partnership have to be provided by contributions from partners or through borrowing. A partner cannot sell his share of the organization without the permission of the others. A partner only has the right to transfer the value of her partnership interest, not the interest itself. So if my partnership interest entitles me to a $1,000 payout every year, I can transfer that value to somebody else. But I can't transfer my interest in being a partner in that partnership to somebody else without the partners approving. Dissociation is when a partner leaves a partnership. There are also what we call limited liability partnerships. A limited liability partnership offers the limited liability of a corporation and the tax status of a flow-through organization. Partners are not liable for the debts of the partnership, but are liable for their own misdeeds. To form an LLP, the partners must file a statement of qualification with state officials. LLPs must also file annual reports. Other attributes are similar to the general partnership. So you'd much rather be in this position than in the position of being a general partner. So as added review, take that chart that we've walked through for the organizations up to this point and fill it in for general partnership and fill it in for limited liability partnership. Make sure you understand the tax status, the personal liability. Make sure you have those things clear so you understand the distinction between a general partnership and a limited liability partnership. We talk about professional corporations. They offer the limited liability of a regular corporation. PCs have some limitations. All shareholders of the corporation have to be members of the same profession. Required legal technicalities for forming and maintaining a PC are expensive and time-consuming. Tax issues are much more complicated than for an LLC or LLP. A joint venture is a partnership for a limited purpose. It's not technically a legal entity, so all tax liability is shared among the participants in the venture. The participants also share any liability that arises out of the joint venture's activities. Franchises, another example of something that's not strictly speaking a separate form of organization, but the trademark owner, who we call the franchisor, licenses the trademark to the operator or the franchisee. The advantages of a franchise: you get to own your own business and you have lots of support. The drawbacks are you have somewhat limited control and there are lots of costs: an initial purchase fee, royalty fee, you have to buy supplies, pay for joint advertising, there are system standards. that place a lot of limitations on your flexibility. There are lots of legal requirements. All franchisors have to comply with Federal Trade Commission rules. So there are a lot of restrictions and legal requirements when it comes to franchises. That brings us to our last chapter of the semester, which is Chapter 7 and crime. So we're going to go ahead and go through Chapter 7, wrap up the semester. You'll be well prepared for Exam 3, and hopefully you'll all knock it out of the park. So let's go through a review of our last chapter. White-collar crime costs society tens of billions of dollars annually. Crime is detrimental to society. Even the fear of crime can be costly. 3 parts to the chapter. We're going to talk about criminal procedure, crimes that harm business, and crimes that are committed by business, with most of our focus on the criminal procedure part. Civil versus criminal case, we talked about this way back when in Unit 1. Civil law involves the rights and liabilities that exist between private parties. Criminal law prohibits and punishes conduct that threatens public safety and welfare. Prosecution, only the government can prosecute a crime. We talked about that. Don't miss a question that might come up on the exam about that. Only the government gets to prosecute crime. Also, don't miss a question about this because we've talked about this back in Unit 1 as well. The burden of proof in a civil case is preponderance of the evidence. The burden of proof in a criminal case is beyond a reasonable doubt. And beyond a reasonable doubt is a very high burden of proof in a criminal trial that demands much more certainty than required in a civil trial. So the burden of proof in a criminal case is higher than the burden of proof in a civil case. A criminal defendant has a right to a trial by jury for any charge that could result in a sentence of 6 months or longer. A defendant could choose to have a bench trial, and a bench trial is a situation where there is no jury. The judge is the one who reaches the verdict. The distinction between felonies and misdemeanors is important. A felony is a serious crime for which a defendant can be sentenced to 1 year or more in prison. A misdemeanor is a less serious crime, often punishable by less than a year in county jail. So the distinction between felony and misdemeanors is determined by how long someone can go away and where they go to. So that's how you make that distinction between felony and misdemeanor. To win a conviction, prosecution has to demonstrate to the court that a statute has outlawed the defendant's conduct. 5th and 14th Amendments to the Constitution require that the language of criminal statutes be clear and definite enough that ordinary people can understand what conduct is prohibited, and enforcement cannot be arbitrary or discriminatory. A prosecutor has to prove that there was a voluntary act, that a defendant is not guilty of a crime if she was forced to commit it. In other words, she's not guilty if she acted under duress. And when the government induces the defendant to break the law. So they were not predisposed to commit this crime. The defendant was not. The government coaxed them into doing that. The prosecution has to prove beyond a reasonable doubt that the defendant was predisposed to commit the crime if there is this claim of entrapment. It's illegal to conspire to commit a crime even if the crime never actually occurs. A defendant can be convicted of taking part in a conspiracy if, 1, the conspiracy existed, 2, the defendants knew about it, and finally, some member of the conspiracy voluntarily took a step towards implementing it. Now let's talk about the 4th Amendment. 4th Amendment to the Constitution prohibits the government from making illegal searches and seizures of individuals, corporations, partnerships, and other organizations. As a general rule, the police must obtain a warrant before conducting a search, and a search warrant is simply written permission from a neutral official, such as a judge or magistrate, to conduct a search. A warrant will be issued only if there's probable cause, and the standard of probable cause is that it's likely that evidence of a crime will be found in the place to be searched. A warrant must specify with reasonable certainty the place to be searched and the items to be seized. A search with a warrant can still violate the 4th Amendment when there's no probable cause to issue the warrant in the first place. The warrant does not specify the place to be searched and the things to be sought, or the search extends beyond what is authorized in the warrant. There are situations where you can search without a warrant. If something is in plain view, the police have the ability to search and confiscate without a warrant. If you're a stop and frisk situation, the police can pat you down to make sure that you don't have any weapons or anything that would be dangerous to them. In certain emergency situations, they don't have to have a warrant to search. With automobiles, if you get pulled over on the side of the road, in many circumstances, as long as they have probable cause, they are able to search your vehicle in the absence of a search warrant. If you're placed under lawful arrest, they can search without a warrant. And if you consent, they can search without a warrant. So there are situations where there's no expectation of privacy. Police have the right to search any area in which the defendant does not have a reasonable expectation of privacy. So the textbook goes through several examples. I'm going to hit them at a very high level and just kind of brush over them just so I can mention them. DNA test, the textbook talks about blood versus breath test, heat-seeking devices, digital cameras, cell phones, computers, GPS, email, websites, internet messages, social media. The reason I just went through those quickly is because I want you to have a sense of the challenge that courts face. So the Fourth Amendment says that we're free from unreasonable searches and seizures. What exactly does that mean when we're talking about internet searches and social media and GPS tracking and heat signature from our homes? Like, all of those things are things that courts have to struggle with. So I'm not concerned that you know the specific details of all of those necessarily, just the fact that courts have to struggle with those particular issues. The exclusionary rule says that any evidence the government acquires illegally or any information obtained as a result of this illegal behavior is not able to be used at trial. The three exceptions to this rule: if there is inevitable discovery, they would have found it anyway, there's some independent source that led them to it, or they were acting in good faith and they didn't intend to violate the rule, then that evidence is not excluded from trial. So what happens after arrest? Well, the Fifth Amendment says that you're entitled to due process, requires fundamental fairness at all stages of the case. Prosecution has to disclose evidence favorable to the defendant. Lineups have to be reasonable. Fifth Amendment also bars the government from forcing any person to testify against himself. Protection applies only to people, not corporations or other organizations. You're entitled to Miranda rights. Police must inform suspects of their rights. You have a right to a lawyer. A criminal defendant has the right to a lawyer before being interrogated by the police. Sixth Amendment guarantees the right to a lawyer at all important stages of the criminal process. Government has to appoint a lawyer to represent free of charge any defendant who cannot afford one. We then have an indictment. A grand jury is a group of ordinary citizens who decides whether there is probable cause the defendant committed the crime with which she is charged. The grand jury usually holds hearings on several cases for several weeks at a time. At the hearing before the grand jury, only the prosecutor presents evidence. If the grand jury determines that there is probable cause that the defendant committed the crime with which she is charged, an indictment is issued. An indictment is just the government's formal charge that the defendant committed a crime and must stand trial. The defendant is then brought to court, charges are read against them, and they enter a plea. There can be plea bargaining, which is an agreement in which the defendant pleads guilty to a reduced charge, and the prosecution recommends to the judge a relatively lenient sentence. Prosecution is obligated to hand over any evidence favorable to the defense that the defense attorney requests. The defense has a more limited obligation to inform the prosecution of its evidence. We then get trial, and we can have appeals. It's very similar in many ways to a civil trial. The standard is beyond a reasonable doubt. The appellate process is similar to the civil appeals process. Then we have double jeopardy. A criminal defendant may be prosecuted only once for a particular criminal offense. Eighth Amendment prohibits cruel and unusual punishment, also outlaws excessive fines. Okay, now we talk about crimes that harm business and their customers. We'll talk about these at a fairly high level. Larceny is the trespassory taking of personal property with the intent to steal it. Trespassory taking means someone else originally has the property. You can contrast that with embezzlement. This is the fraudulent conversion of property already in the defendant's possession. Fraud is deception of another person for the purpose of obtaining money or property from him. Wire and mail fraud involves the use of interstate mail, telegram, telephone, radio, or television to obtain property by deceit. And then there's also insurance fraud. Now we have internet fraud. We see this identity theft, phishing, auctions. The amount of fraud on the internet is just expanding at an incredibly rapid rate. Arson is the malicious use of fire or explosive to damage or destroy any real estate or personal property. It is both a federal and state law crime. Hacking is gaining unauthorized access to a computer system, another crime that we are seeing growing in frequency and in amount of harm that it impacts or inflicts upon business. Crimes that businesses might commit. A corporation can be found guilty of a crime based on the conduct of any of its agents, who include anyone undertaking work on behalf of the corporation. If an agent commits a criminal act within the scope of his employment and with the intent to benefit the corporation, the company will be liable. Some examples: making false statements, workplace crimes, for example, under OSHA. The Racketeer Influenced and Corrupt Organizations Act, RICO, is a powerful federal statute aimed at organized crime. It's now used against many ordinary businesses. There are several steps in a RICO claim. Money laundering is another example of a crime that businesses may commit. Hiring illegal workers, violations of the Foreign Corrupt Practices Act. The FCPA has two principal requirements dealing with bribes and record keeping. And then some other crimes. Increasing number of federal and state statutes are designed to punish those who harm the environment. Antitrust violations, security fraud. How can you punish the corporation? Well, fines, compliance programs are some of the things that courts may use. That concludes our review for Exam 3. I will say this multiple times in class. You've all been a pleasure to work with this semester. If you have any questions as you prepare for Exam 3, please let me know. If I can do anything for you once the semester wraps up, please feel free to reach out to me. I'm always happy to help however I can. I hope you all stay in touch. Best of luck on this exam and any others that you might have this semester, and I'll see you all in class.